You're not going to want to miss today's episode. It's all about the new, latest and greatest rent control law in California. Stay tuned. Okay, so today we are going to be talking about kind of the state of statewide rent control, no pun intended, in California. So long story short, the state came out with a new law, or it's not necessarily new, it's a new version, I guess, of the law, Senate Bill 567, and it is essentially going to complement and or replace Assembly Bill 1482. But I wanted to do a podcast that kind of just goes over how we got here. Like, what does this mean? What does the future look like when it comes to rent control? And, what are the changes? So the first thing is the rent control just got worse for landlords, right? It just got more strict, more stringent. Penalties got worse. Tenants have, unfortunate, I don't know about unfortunate or fortunately, but more rights, more things that they can do to landlords, i.e. they can sue landlords now over some of these issues. So there's a lot in here that is not favorable to landlords. And that's not the purpose of the podcast. Although we have opinions on rent control in general. I think most economicists do, and they're generally not favorable. But the purpose of today's podcast is to give you start to finish, how do we get into this mess? And where are we going with it? So for starters, back in 2019, going into 2022, the California State Assembly passed Assembly Bill 1482. It's called the Tenant Protection Act of 2019. And what they were trying to do is get statewide rent control, because there are political factions in the state that think that housing can be solved by regulating the price of it, i.e. rent control. And this is their first attempt at that. And I should say, this isn't the first attempt. This is the first successful attempt at getting a statewide initiative passed. Now, plenty of other municipalities have rent control already. Think of the city of Los Angeles, the county of Los Angeles, Oakland. Rent control is nothing new. What's new is that this is statewide, and it applies to not every property, and we'll go over what it does apply to and what it doesn't, but this is the first swing and home run at a statewide proposition. Sorry, it's not technically a proposition, it's a bill. So, okay, what was 1482? Why did we get there? And I think this is important to outline. The real root cause of the problem of our housing being so expensive, both on if you want to buy a house and or rent a house, it's a simple supply-demand equation. There's not enough housing supply. It's driving the prices up. Politicians are looking for ways that they can influence this and bring the prices down. That is, in my mind, why they try to do rent control laws. The reality is, and this has been proven over and over again, is rent control doesn't really fix the problem. It does help the people who are in housing currently that are now controlled by rent control, because they got, quote unquote, a good deal, but it hurts people that aren't in rental housing. And let me just go over how that works. So a perfect example of this is New York City. New York City has pretty aggressive rent control policies and laws in their area. In fact, we just had the gentleman from New York City on our podcast, and he was giving us more insight on that. So if you live in a rent-controlled unit in New York City, you have affordable housing. You're sitting pretty. It's way less than any of the market rate rent housing that's around you. And they have provisions where you can pass it down to family members. Essentially, once you're in there, the landlord's going to have a tenant for life. And they regulate how much you can raise the rents, all those things. They're nowhere near market rate. I don't know if it was like double or triple what market rate rents are. And I'm sure it varies by location, like all real estate. But the people that have the housing are sitting pretty. The people that don't are kind of in a tough spot, because now they have to compete for a market rate rent property, and landlords have to make up for this somewhere. So if they have properties that aren't controlled by the rental, rent control laws, the prices start going up, especially because all those controlled units are essentially gone away from the market. People are in them and they're not leaving. Now they can increase rents, but it was really a constrained supply of available properties. And then it ends up hurting people who are looking for new properties to rent. It also discourages people from moving, which makes it really difficult for a landlord to improve the property and make upgrades because the tenants never leave. It's all the way around not a good idea for tenants. And that's the part that's hard to swallow with these laws is the very people that they're trying to protect and help, i.e. the tenants, are the ones that are getting hurt the most. And they're also the ones that are supporting these laws. So it's like watching somebody think they're doing a good thing and they're really just making their own life more difficult, which is hard to watch. So 2019, statewide rent control comes in. It just happened to be that this came at like the worst possible time, which was right at the beginning of COVID. To go over that, there's two sections of the law. One is what they call just cause eviction, and one is the actual rent control or price control. Let's talk about the price control first. So there's something called the Consumer Price Index, which is an economic gauge of how much stuff costs. And we're not going to go into super detail on that, but just know this has nothing to do with your landlord. This is a formula that's out there that economists figured out that are much smarter than you and I. And they rate the CPI every single quarter. And they rate it based on location. So like the CPI of Los Angeles is probably different than the CPI of Omaha, Nebraska, right? For obvious reasons. So the law says that no one can raise rent on a property that's subject to this law more than 5% plus the CPI or 10%, whichever one is less. It just so happens our current amount that we can raise rents on these properties right now is 9. So it wouldn't be 10, it would be 9. But that changes. And the CPI is, adjust for inflation and all kinds of other things. So if your property is covered by it, can't raise it more than 10% ever, unless, or it might be less if the CPI plus 5% is less than 10%. One good thing is if your tenant moves out, you then can raise the rents to market rate rents. There were some proposed laws that would not allow that, and they would keep rents low even at turnover, which is even worse for landlords, not the state of what's going on today. So that's the price control section of it. This law doesn't apply to everybody. And that's really important because there are properties that don't have to follow these rules, which thankfully, that's quite a few properties in California. And the exemptions from the law, I'll just go over them just so we're crystal clear on what they are. Okay, so which properties are exempt from 1482? So any unit constructed in the last 15 years, so new multifamily, exempt from the law. Units that are controlled by a housing authority, anything that requires like income restrictions are typically exempt from the law. A single family home is exempt unless it's owned by a corporation, a real estate investment trust, or an LLC where one of the members is a corporation. Duplexes are exempt if the owner lives in one of the properties, and it matters who lived there first, if it was 2 tenants and then an owner, or an owner and a tenant. So just keep that in mind. And because this is a general overview, if you're in one of these situations, you probably need to talk to an attorney to make sure that you're doing the right thing. Some student housing and dormitory types of housing are exempt as well. Okay, so that is who's exempt from 1482. We already talked about the price control section of 1482. The other big section, which in my opinion is the worst, less favorable for landlords, is the just cause eviction component of the law. And basically what it says is you can't just tell your tenant they have to move. And this is assuming that you're subject to the law. So if your tenant is in the property and you just all of a sudden say, you know what? I think I'm going to have those tenants move. I'm tired of them, or I don't like them anymore. You can't do that anymore. You have to have a reason for telling your tenant to move. And one of the reasons is that you're going to take the property back. The owner is going to occupy the property. And that is a valid reason. Now, this is 1482, and this is changing at the new bill, but I'm just trying to give you some historical context to that. Some landlords were taking advantage of this, which is why I think we now have stricter requirements for this in 567, which we'll talk about shortly. If you're going to substantially remodel the property, that was a reason to take it to tell your tenant to move. The problem was it was not super clear, and landlords also some bad actor landlords were taking advantage of this to kick out tenants. And then another one is if you're going to withdraw the property from the rental market, i.e. you're no longer going to rent it out. You're either going to sell it or, leave it vacant for somebody else, or whatever the case may be. Those were the real reasons on how you could be exempt from the just cause provision. If those things don't apply, you have to do what they call give your tenant the proper notice and pay them a relocation fee. The relocation amount is 1 month's rent. So if your tenant, has the rent's $4,000 a month, you got to pay them $4,000. You got to do it within 15 days of giving the proper notice that they have to move. And the theory is they then take that money and they, go find a house somewhere else, and everything is good. Now, if they fall under these exemptions from just cause, like the owner's going to move in, substantial remodel, those types of things, you got to pay them. If they have an at-fault eviction, meaning they stop paying their rent, they started violating the lease, anything you would typically file an actual eviction for somebody against, you don't have to pay for that because they're breaking the contract that they have with you, i.e. not paying the rent or, unauthorized pets or people or things along those lines. Okay, so I don't want to spend too much time on 1482, but that's the gist of it. And the reality is there wasn't much, there wasn't any teeth behind 1482. There was some language in there, but it wasn't being enforced. People were kind of just doing whatever they wanted. I think the state of California said, oh, okay, you guys, this isn't really fixing the problem. Well, we're going to come out with a bigger and badder law. And here comes Senate Bill 567. So it basically strengthened the just cause provisions. It didn't do anything to the rent cap, the price cap portion of it, which was good, but it strengthened the just cause protections for tenants. And this is where it gets a little worse for landlords. Now, instead of those reasons why you could take the property, you could ask your tenants to leave and pay them the relocation fee, they just made it stronger. So if the owner's going to move in to the property or a relative of the owner, you have to tell the tenant who's moving in. You have 90 days to have them move in, and they have to be of a certain family. And I think the term is like one up, one down, meaning the owner of the property can have their parents or grandparents move in, or their children or grandchildren move in. You can't have an uncle or a second aunt or anybody outside of that like pretty well-defined lineage can move in. And then they have to live there for 12 months. And if they don't live there for 12 months, then you have to offer the property back to the previous tenant at the previous rent amount. So they're just putting teeth into it as to why, they're trying to stop people from using this as a loophole to get tenants out. The other one is the substantial remodel. So I believe in 1482, it was substantial and they tried to quantify what that is, but now they came out and said, actually what that means is whatever needs to be done can't be done in 30 days. You have to outline what needs to be done to the tenant. You have to show permits to the tenants before you kick them out, which, by the way, can be very difficult to do because in order to get permits, sometimes you have to have inspections done. It takes a long time from the city or the county that you're getting the permits for. But in order to use this, use this to get rid of your tenant, you have to document all of these things. Again, they're putting the onus on the landlord. It's more expensive. It's harder for them to do what they want to do with their property. So let's talk about what if the owner of the property wants to withdraw from the rental market. Again, more strict rules surrounding this, how long it has to be withdrawn, what happens if you rent it out before that. I believe it's 12 months. It could be, it's either 12 or 24 months. I don't want to get, and by the way, we're not giving legal advice. We are just reporting on what this new law is and potentially, who it's going to affect. Which I will say that if you are questioning this or you think your property is subject to this, you need to talk to an expert, contact an attorney who understands the lawsuit. Don't make mistakes because we're about to get into what happens if you make a mistake, whether knowingly or unknowingly. So if you're going to take the property off the market, you have to keep it off for a certain period of time. If you don't do that and you re-rent it, you are opening yourself up to what they call treble damages. And let's talk about what that is. So the biggest difference of what this law did was it now gives the tenants the right to sue you in a civil action. It also specifically authorized like city attorneys, county general counsels, attorney generals to sue landlords on behalf of tenants. So we have the potential to have some activists, city officials, filing lawsuits against landlords. The problem with that is That's bad for landlords, and they also have what's called treble damages, and all of this stuff is not been litigated, right? I don't believe anybody's been sued under these laws because the law just went into effect April 1st. Although I don't know that for sure. I'm sure somebody's pulling up a lawsuit as we speak. Let's just give you an example. Let's say an owner wants to remove the property from the rental market and move their family member in. So they give proper notice. They pay the tenants, hey, you guys got to go. We're moving, my son Johnny in. Johnny does or doesn't move in, but only stays for a couple of months and then moves out. Now they have a vacant property. Well, they didn't go back to the previous tenant and offer it to them at the same rent. They just decided, well, I don't know where that previous tenant is. We'll just put it up on the for rent on market rate rents. And maybe it was $3,000 a month before, and now the rent's $4,500. Well, if the previous tenant gets a whole, figures this out, and now there's a $1,500 difference what the previous tenant was paying to what the new tenant was paying, and say the old tenant took 2 years to figure this out. So for 2 years, the landlords collected $1,500 a month in rent. Let's just do quick math on that. So they've collected essentially $36,000 extra in rent. Tenant catches wind of that. Tenant now has the right to go sue the landlord and say, you didn't offer that property back to me at what I was paying before. My damages are whatever rent I had to pay above what I was paying with you. So if he left his $2,500, $3,000 a month rental, and now he has to go pay $4,500 somewhere else, and he can document that, then he can come after the landlord for that difference. How successful they're going to be is anybody's guess. Whether a judge is going to follow this to the letter of the law, who knows? I mean, that's the problem with these laws, is you don't know until a lawsuit's filed and some precedence is set legally. But you could easily make the argument that there's $36,000 in damages times, over 2 years, and then they're going to triple that, and they're probably going to put in there for their moving expenses that they had to pay, the security deposit they had to pay, a whole bunch of stuff that I'm sure an enterprising attorney is going to add to that number. So let's say they get a $36,000 judgment, and then the judge triples it. Now you're out $106,000 over something that just because you were careless or you didn't follow the law as it was prescribed. And now this is what you're opening yourself up to. The point of this, and what really matters in the end, is that if you're going to be a landlord in California, you need to be aware of these changes and these laws, and you need to follow them, because the consequences are real now. There are going to be lawsuits from tenants. There are going to be pro bono legal groups that are going to represent tenants, probably on a contingency basis. And I guess that wouldn't make them pro bono, but there are going to be enterprising lawyers that pop up who are going to be searching for these lawsuits. Happens every time when something like this happens, and it's bad for landlords. So what landlords need to do is follow the rules, because it will come back to bite you if you don't. And you don't want to be in a situation where you were so worried about collecting a few extra $100 in rent that you crossed some line and you made a mistake, and now it's going to cost you $50,000 because of that. The numbers don't add up. The only sensible solution here is to follow the law and do it as it's, follow it as it's written. We don't agree with the law. I think the law is ridiculous, and probably it's going to be counterproductive and it's going to hurt tenants, but that's irrelevant. What's relevant is that the bill was passed, the governor signed it, and this is the new reality in where we're operating as landlords in California. So I hope that makes sense. Those are the big things with it. Again, don't take this as legal advice, because it's not. If you're in a situation where you think this law applies to you, or you're not sure what to do because you want your tenant to move, reach out to legal counsel. It's probably the best money you could ever spend. Worst case scenario, you spend an hour of an attorney's time, but you get good advice and you stay compliant, and you don't have to deal with, a lawsuit where you have the potential to get a big judgment against you. If you know somebody in the state that is dealing with this, make sure you share this with them. Another big one that I overlooked that I think is worth mentioning is the just cause protection in 1482 kicked in after 12 months. The just cause protection in Senate Bill 567 kicks in on the first day. So if you have a property that is subject to this law after day one, you have to follow this. And then they also, as far as the properties that were not exempt, there was some changes to that too. And it had to do with short-term rentals. Let me find it here really quick for you. Yeah, so now it's single-family homes not owned by a corporate entity or short-term rentals 30 days or less are typically exempt. So if you have a short-term rental and somebody stays over 30 days, which is relatively common, then you're now subject to this law. Again, I don't think a reasonable person would expect that if they stayed at your house for 31 days that on Airbnb that you now have to pay them to move, but this is going to be tried. Somebody is going to try this, especially with all the issues that are out there with squatters and squatting in short-term rentals and whatnot. That's definitely going to be something that comes up, and you just want to make sure that you're not the guinea pig, you're not the test case for this law, because somebody is going to be, and hopefully it's not somebody that we know or that we take care of their properties. We're going to do our best to follow this law, and my advice would be that everybody else do the same. Thank you so much for listening to our podcast. If you like this content, share it, like it, give us a review. We appreciate our listeners. We are always looking for feedback. Feel free to email us at podcast@rinconmanagement.com. If you have suggestions on future shows you'd like to see, guests you'd like to have us bring on, anything along those lines, we definitely are all ears for that type of feedback. Thanks, guys.